Ready to go.
Okay, thank
Thanks,
you.
Ruth. I'll just share the presentation on my screen and then we can go. Okay, can everyone see this? Okay, my name is Mike. I'm from the law firm West Coast Wills and Estates. We have 3 offices, North Vancouver, West Broadway, and Burnaby. We practice in estate planning, probate, and corporate and tax law. Today, we'll talk about estate planning and incapacity planning. Hopefully, there's a lot of information for you personally and for your patients as well. So a lot of information in this presentation. Take notes if you want. So let's get into it. What is estate planning? Just generalities. It's providing for loved ones in the most cost-effective, quickest, and dispute-free way. We also lump in incapacity planning with estate planning, just because you hear once in a while that you need a will, but you never hear that you need a power of attorney or a representation agreement, and they're equally as important. So I make a point of talking about them at every talk just because it's so important. So incapacity planning makes it easy to care for you if you should become incapable and in hospital. So what is estate planning? It's not jumping to the will. The estate planning is the umbrella under which a will sits, but other items sit under it as well. So there's life insurance involved in estate planning, beneficiary designations of various assets. There's joint ownership of different assets. There's the will, there's trusts that you can do. There's giving away your assets during your lifetime, sometimes a down payment to help a child. That's a form of estate planning. And then obviously the incapacity documents, just like the power of attorney and healthcare documents. So this is pretty much estate planning 101, this slide. And there's actually 3 ways your assets can pass when you die. The first way is beneficiary designations. And so when you beneficiary designate someone to take over the proceeds of a life insurance policy or a pension plan, it goes straight from the financial institution to those people when you die. The second way assets can pass is through joint tenancy or joint ownership, usually with a spouse, especially if you own a piece of property or a bank account jointly with a spouse. If one of you dies, it automatically goes to the survivor. We call that right of survivorship. And the third way things pass is through your will. We call that your estate. So I'll just delve into these 3 categories for the next 10 minutes or so, just starting with beneficiary designations. So you can beneficiary designate these following assets. So life insurance policies, pension plans, RSPs. When you turn 71, RSPs turn into RIFs. So you can also keep on your beneficiary designation for that. And tax-free savings accounts. Segregated funds are in here. They're sort of like a mutual fund wrapped in a life insurance wrapper. So you can beneficiary designate those. It's typically higher fees for those, so I don't recommend them very often. Just an estate planning gaffe that a lot of people make. They don't realize that RSPs are taxed when you die as income. So if you have $300,000 in RSPs or RIFs when you die, that's a $300,000 income from you on your tax return, and you pay the equivalent amount of taxes owing to the government. The only exception to that is if you name a spouse or a dependent child as beneficiary of that RSP or RIF, in which case it just rolls over tax deferred to them. And then when they take it out or die, then it's taxed as income to them. So what a lot of people do, some people do, is an estate planning gaffe. They give their home to one person, one of their children of two, and then they give their RIF to the other one, not realizing that the RIF has a huge tax bill associated with it. So it's unequal division between the two when people wanted the equal division between the two children. Joint ownership. Before I get into what joint ownership is, it's important to know that there's two types of ownership with two or more people. Joint ownership is one, and tenants in common is the other. Joint ownership is typical with a spouse. It's called joint tenancy. And as I mentioned before, it's the right of survivorship. So if spouses own a home or a bank account or an investment account in joint tenancy, if one of them dies, it automatically passes to the next, to the survivor. Tenants in common is seen more like when a vacation property is passed down from parents to siblings. They don't want the first to die of them. They don't want to pass it to the remaining siblings. Oftentimes they want to pass it to their own children, but down by the line. And so we'd see that as percentage ownership. Say there's 3 children, a third, a third, a third. And that allows it to pass by the will of each of those children. And so they can say in their will, I want my percent of this vacation property to pass to my children. And that's the way it works. So with joint tenancy, there's a law that barely anyone knows about, but it's super important. So the law presumes that when spouses own something in joint tenancy, so again, it's a home or bank account, it's for survivorship purposes. So when one spouse dies, it automatically goes to the surviving spouse. That's what I just said before. But oftentimes that surviving spouse then thinks that was easy. So I want to put my own children on my home title, on my bank accounts to make it easy for them, not realizing that this is a different law that applies in this case. So the law that applies when an existing home or an existing bank account gets put in the name of in joint names with the parent and a child, the law says that the child is just on there for convenience, and it actually passes according to the parent's will when the parent dies. And so it's called a resulting trust. So the parent gets taken off of the bank account, but then the child has to hold it in trust and pay according to the parent's will. That is a rebuttable presumption, it's called. So if the parent truly wants the child to inherit that account or that piece of real estate, they can say so in writing, dated, signed at the time of transfer into joint tenancy. They can say, I want my child to inherit this property instead of having it pass according to my estate, my will. When that's done properly, typically with the help of a lawyer, just to make sure this legal documentation is proper, that rebuts the presumption that the law makes, and the child does inherit in that case. I can tell you 99% of the time when we see joint accounts, there's no such documentation, and we see it 2 or 3 times every week that an executor we help has a joint account, and there's no documentation, so the joint account has to be passed according to the estate, according to the will. Other dangers in adding a child to your accounts, or you being added to your parents' accounts, or real estate, there's 3 major ones. It becomes available to that child's creditors. And so there was a case 3 years ago now in BC, and there was seemingly simple estate plan. It was a widow and her only son. Simple, right? So she just put, I don't know who advised her to do it, but she put her principal residence in joint names with her son. Someone probably said you can avoid the probate tax by doing that, which is sometimes possible if done right, but that's besides my point. The son, years later, he was a real estate developer. He went bankrupt. And what the creditors did is they did a land title search, which is a publicly accessible registry in BC, and they found out that he owned land. So they claimed against that land. The mother and the creditors went to court. The mother saying, "Oh, it's my land. It's not my son's. He's just on there just for convenience." But the court sided with the creditors. And when the mother died or sold the house, the creditors would be able to claim half. Keep in mind, much more common than that, a creditor could be an ex-spouse. So say, same situation, the mother put her property in joint names with her son. 10 years went by, and then the son got divorced. All of a sudden, it's the daughter-in-law, which the mother never liked in the first place, is claiming against the mother's home because she has a claim to it in that separation from her son. So that's a real worry. Second danger is capital gains. So I'll just give you a brief overview, massively oversimplified view of capital gains. Capital gains is basically the profit you make off selling an investment property or a stock. So if you buy it for $100 and you sell it for $300, there's a $200 capital gain there. And conventionally, that's taxed. You include 50% of that in income and it gets taxed. Trudeau announced an amendment to that tax rate, but I don't think that'll go through now. But anyway, that's beside this point. It gets taxed, that profit. There's a huge gift that the Canadian government has given us, and it's called the principal residence exemption to capital gains tax. So it says when you own a home and you live in there, it's called your principal residence. And despite the fact that it went from $100,000 when you purchased it to $2 million when you sold it, you don't have to pay capital gains tax because it's your principal residence. Now back up to our conversation about putting children on title. We see it all the time. Children are on title to their parents' principal residence. Huge problem because the parents don't own it anymore. Half owner is the child. And typically the child doesn't live there. They have their own principal residence and you can't have two. So that capital gain for half the property is taxable in the hands of the child. And so that's giving away the hugest gift the government's given the parent in the principal residence exemption. It's just giving it away and making half of that a taxable asset if you put your child on title. So that's a huge faux pas in this estate planning world. The last one is obvious, but it's kind of sad. Twice a month-ish, people come into our offices and the meeting starts off well enough, conventional will they're looking for, but then about 5 minutes in, it becomes obvious that they haven't talked to their son or daughter for 20 years, let's say, and they want to cut them out of the will. Obviously, if you've put that child joint on all your bank accounts and real estate, it's too late. You can't cut them out because they're half owner of all your stuff. And you can't take it back unless they sign it over. And if the relationship's frayed, they're not going to sign it over. So that's another danger in putting children joint on your assets. So that was the second way things pass, joint tenancy. So the first way was beneficiary designation. Second way was joint tenancy or joint ownership. The third way, as I mentioned before, is through your will. Where there's no will, it passes to your next of kin according to the default law in BC. And just briefly, what that means is if you have spouse and children, it's divided between them. The spouse gets a preferential either 150,000 or 300,000, and then all the rest is split equally between the spouse and all the children. If you don't have children and you have a spouse, all goes to the spouse. This is, of course, if you don't have a will. If you have a will, you can say whatever you want. If you don't have a spouse and you have children, it gets divided equally between the children. Then it goes down and then up and then down. So by that, I mean, if you don't have a spouse or children, it goes to grandchildren, great-grandchildren, and then up to parents, and then back down to siblings, nieces and nephews. And you just stop at the class of people who are alive at that time, and the closest class of people who are alive, and they inherit everything. One last time, if there's no one alive, to grandparents, and then down to aunts and uncles, first cousins. If there's no one left alive in all those classes, it actually goes to the government. So that's another reason why it's important to do a will if you don't have any next of kin apparent. So if assets are substantial, the probate process is needed for both cases. If you have a will or not have a will, probate is needed regardless if assets are substantial. And what do I mean by substantial? If you have about 25,000 or 30,000 in a bank account, the bank is going to ask your executor for probate, which is a court application just to stamp the will as valid, because the bank wants to know if this is the most recent will, because if you've done a more recent will that cancels that will, that's a problem. And that it's a valid will, because if you didn't sign it, for instance, that's not a valid will. And so the bank's doesn't have legal expertise, so they leave it up to the court to go through this probate process. So wills, only 50% of Canadians have an up-to-date will. So look at your group here, and probably 50% of you only have an up-to-date will. And from my experience, it doesn't have anything to do with profession or the amount of assets someone has. It's more of a personality trait. Some people do things because it's the right thing to do, and eventually they'll need a will. Some people only do things when they have to. And so if you're the second type, probably you don't have a will, or you don't have an up-to-date one at least. Basically, a will is instructions for what to do when someone dies, relatively inexpensive, peace of mind, and a must-have estate planning document. So every will starts out with choosing your executor. An executor is a person in charge of carrying out the directions in your will. So they do everything from arranging your funeral. They hire a lawyer to apply for probate if needed. They file your taxes with the help of an accountant. After probate, they gather up all your assets and combine them into one central account. They pay all your taxes and remaining debts. And then finally, they pay to who you say to in the will. There's 10,000 steps in between, of course. It takes about a year to 2 years. So it is a part-time job. Good traits you're looking for in an executor are trustworthy, responsible, somewhat local. Local to your city is best. Local to BC is second to best. Local is somewhere else in Canada. It's doable. We help executors with BC estates located in Ontario all the time, and it's doable. Not ideal, but doable. Don't pick an executor outside of Canada. For tax reasons, it's taxed as a foreign estate in that case. And for logistical reasons, obviously, if you pick someone in South Africa, they're going to be up in the middle of the night, all night, sometimes dealing with realtors and accountants and lawyers in Vancouver. They should be good at delegating to professionals because they're personally liable for mistakes that they make. So if they sell your house themselves and it was undervalued, the beneficiaries can sue them. If they don't file your taxes correctly, CRA can come back at them 4 years later and reassess and levy penalties upon them personally. And so they should be good at delegating to professionals to clear themselves of that liability. Good communicators, they're dealing with professionals on one side, beneficiaries knocking on their door for the money. When's the money coming? When's the money coming? So they have to be good communicators to be able to allay those concerns. And finally, they have to have some time on their hands. It is a part-time job for 1 or 2 years average. So, and that's why I put this next note. It's not necessarily bankers, lawyers, or accountants who make the best executors. Theoretically, these people deal with money, but they don't always have time on their hands. And so, especially if they have a young family and a busy job, that they work 60 hours a week, they're not going to have time for your estate. These are some of the worst executors I've ever had to deal with, bankers, lawyers, and accountants, just because an estate is something you can always do tomorrow. So there's no hard timelines in estates. So if an executor is busy doing other things, they'll just maybe do it tomorrow or next week. Mañana, as the Mexicans say. And if there's no one ideal, or you just don't want to put the burden on a loved one, think trust companies. Every major bank owns a trust company, and there's a couple independent ones in Vancouver as well. And the benefit of that is they do the job every single day. They do things right, and there's no mistakes typically. So what can wills say? Wills can give outright gifts of cash, things, or real estate. There's always a residue clause, and don't think slimy mildew. Think all of the rest of the money after the debts have been paid, after all those specific gifts have gone out, the rest of the money gets divided equally or all to my spouse, that sort of thing. Wills can also have ongoing trusts, way beyond the scope of this presentation to discuss the types of trusts. But just so you know, it's a trust. I'll just explain it. It's fairly simple, although it has this mystique about it. Everything in this world has both a legal owner and a beneficial owner. So there's 2 types of ownership. So I own this pen, I use this pen. That's legal ownership. I'm on the receipt of this pen. I use this pen daily. So I have the beneficial ownership too. A trust is simply splitting those 2 types of ownerships. So someone is on the bank account in name, but someone else gets to benefit from that bank account. So the person on the bank account is called the legal owner or the trustee. The person who benefits from the bank account is called either the beneficiary or the beneficial owner. So all a trust does is split those 2 types of ownership. I'll just highlight one type of trust. There's dozens, as I mentioned before, but a Henson trust is handy for you to know because you're in the healthcare profession and you deal with disabled people all the time. And so to qualify for disability assistance in BC, you have to have a qualifying disability first, but then there's also an asset and an income test. So the income test is, I think, around 15,000 in annual income or less to qualify, above which they won't qualify for disability assistance, provincial. And they can have a maximum of 100,000 in their own name, excluding a house and car. And so obviously, if a parent gives this person with a disability $200,000 cash in their will, they get kicked off of disability assistance, which is more than just the monthly check. Sometimes it's tied to housing, sometimes it's bus passes, medication discounts, educational opportunities. So you're removing them from their support system completely, which is devastating for some people with disabilities. So the answer to all this is called a Henson Trust. It's putting someone else, giving that $200,000 gift to someone else to manage as trustee for that person with a disability. And so that person in charge is called the trustee. They pay out for that disabled person's benefit for the rest of their lives. Whatever they need help with, they can pay out of the trust fund for. And the ministry is totally on board with these. All they ask is that the trustee provides them with an annual report of what went in and out of the trust account, just to make sure they're not disqualified. Special sort of things that might apply to you or your patients. Real estate outside of Canada is the main one. So if you own real estate outside of BC, for that matter, real estate passes according to the jurisdiction in which it sits. So if you own a cottage in Ontario and you die, your will needs to be brought to Ontario and reprobated in their courts. Probated in our courts, then brought to Ontario and reprobated in their courts. So the answer to this is just do 2 wills, one for Ontario, one for BC. Not so crucially important when it's in Canada because the laws are sort of the same, but you can imagine owning real estate in France. Their laws are completely different than ours, and our wills drafted in BC most likely will be illegal, just not legal in France to pass that property. So it's essential in that case that you have a French will excluding BC assets and then a BC will excluding France assets. To the same sort of feeling, you can also do 2 wills for company owners. So if you're an owner, if you have a medical practice in a company, private company, you can do a will for the company shares, and you can do a will for all the rest of your assets. And what this achieves is there's a probate tax in BC of 1.4%. And so everything that goes through probate gets this 1.4% charged on it. And so if you own a home worth $2 million, that's $28,000. If you own a company worth $3 million, that's $42,000. So you can avoid that probate fee on the company because probate, your company, you're not requiring your own company to go through probate. So what you do is a separate will for your company, and that doesn't get probated. And then you do a will for all the stuff that does need probate, like your bank accounts and your real estate. The company will avoids probate. It avoids that $42,000 on a $3 million company, and off you go to the races. What might interest some of you approaching retirement is an alter ego or joint partner trust. They're the same sort of thing, but alter ego is for 1 person, joint partner is for 2. And this also avoids probate. So in these, you transfer your assets to these trusts during your lifetime, and the trust continues until you die, and then it distributes the assets to the people who you choose. Because it's not going through the will, there's no probate tax. The 1.4% doesn't apply. And so this is another way to avoid that 1.4% tax. It's only for Canadians over 65 years old. The rules are that any income paid into the trust has to be claimed by you personally, tax-wise. But recently there's been some difficulties putting in real estate to these trusts. So talk to your lawyer about that if you're interested in putting real estate into these trusts. So that brings us to incapacity planning. 2 questions for you. If you're in hospital, unable to respond to doctors, who look after your finances and who look after your personal and health care? 2 questions have 2 different answers. First, the finances is called a power of attorney. And just a note for doctors or other people who are trained in Ontario, Ontario has two types of powers of attorney, one for finances, one for healthcare. Not so in BC. When you use the term power of attorney in BC, it's only for finances. For healthcare, and we'll get to that in a second, it's called a representation agreement. But talking about the power of attorney for financial decisions, a power of attorney lets someone else make financial decisions on your behalf. So if you're unable to make them yourself, these people can step into your shoes, they can run your company, they can pay your bills, they can mortgage or sell real estate. Anything you would be able to do, they would be able to do financially with your power of attorney. Representation agreement, akin to a power of attorney, but is for personal and healthcare. So these people can make personal and healthcare decisions for you. Unlike a power of attorney, though, there is default law in BC that says that your next of kin generally can make most healthcare decisions for you if you don't have a representation agreement. So that's called the temporary substitute decision maker, is what that next of kin is called. Why a lot of people want a representation agreement despite that default law is obviously they can name the order of people that they prefer to look after their healthcare. And it sort of elaborates their power. So representatives in a representation agreement have the right to contract third parties to give at-home healthcare. A lot of these care agencies like to see a representation agreement to make sure that they're dealing with the right person in charge. And they can request doctor's records easier than the next of kin, because who knows who the next of kin is really when you're at a records office in the hospital, for instance. So, and the last reason is because you can name your end of life wishes within a representation agreement, and that legally binds your representatives to follow those wishes. There's two types of representation agreements. The first type is the one I was just talking about. And so typically, just as an overview, most people have three documents: a Section 9 representation agreement for healthcare incapacity, a power of attorney for finances incapacity, and then a will. That's by far like 95% of people who have three documents have those. There is a different type of representation agreement, which is just for people who already are incapacitated. And so that's handy for clients of yours who already have dementia or Alzheimer's or are otherwise slightly below the level of capacity needed for most legal documents. The law for Section 7 representation agreement, in fact, says they don't need to have mental capacity to sign one of these. And so it allows a representative to make most healthcare and most financial decisions for this person, despite their already being incapacitated. So that's a crucial document that is not very well known. Living wills and advance directives. So they typically only state end of life wishes. So a living will, we all know what a living will is, used throughout the English speaking world as meaning a document that specifies end of life wishes or healthcare wishes in general. In BC, we've made living wills into a legally binding document called an advance directives. So living wills technically aren't legally binding. Advance directives are. In all other respects, they're the same. They're just advance directives are living wills that are legally binding. And so these documents plan in advance. I often get asked, so are they just DNRs? No, they're not DNRs because they're planned in advance. When a 40-year-old plans these documents, they're not signing a DNR because, they want to be resuscitated, obviously. So it's a DNR with a qualifier. So if I'm suffering from an extreme physical or mental disability and my death is otherwise imminent, then DNR. So it's not just like a carte blanche DNR. That's the typical language used in these things. Comiteeship. This is a horrible thing to happen, but notice I didn't say that there's default law for powers of attorney. So if someone doesn't have a power of attorney and they are too incapacitated to sign a Section 7 representation agreement, or a house needs to be sold or something major financial needs to be done, their loved ones are faced with one of two options. Either let the public guardian and trustee take over their finances, which comes with an annual fee and a startup fee as well. So quite expensive over the long run, or apply to court themselves with the help of a lawyer and get what's called a comiteeship of person and estate. And so what that entails is quite a large upfront fee, around 8,000, 9,000 on average, to the lawyer fees. Usually takes around 2 to 4 months, maybe 5 months recently. At the end of all this, court orders comiteeship be granted, but it has restrictions to it. There's a yearly $525 fee payable to report to the public guardian and trustee of BC after all that. And so the key takeaway, if you're making dinner and not paying too much attention, get a power of attorney to avoid this hassle, because this is truly the worst case scenario, either letting the public guardian and trustee take over with their huge fees, or putting up a huge fee upfront to have a lawyer apply to the comiteeship. So other resources that you might find helpful is My Voice, which is a BC government document. It's quite extensive, and I find it quite confusing. Well, my clients have found it quite confusing just because it's quite extensive. It's maybe 80 pages, and it goes over all the documents, and it gives samples of some documents. And it's a little bit overwhelming for, say, the average 85-year-old that's reading it. But it is there, and it explains a lot of things very thoroughly. NIDIS is another resource that's great. They have a website. It's a not-for-profit organization that tells you all about incapacity planning documents like powers of attorney and representation agreements. I'll just talk about MAID. I'm sure all of you are aware of this, the next 2 minutes of content, but just in case some of you aren't. MAID is a process, medical assistance in dying is a process that allows someone who is found to be eligible to receive medical assistance in dying from a medical practitioner. The eligibility requirements are the person needs to be at least 18 years old, mentally competent, give informed consent, and have a grievous and irremediable medical condition. So what is grievous and irremediable medical condition? The patient has to have a serious illness, disability, or disease, be in an advanced state of decline that cannot be reversed. And this is the clutch one. So they have to be experiencing unbearable physical or mental suffering that cannot be relieved under circumstances that they themselves find acceptable. So it's not a third-party doctor that says like, oh, you'll be fine with this medication. It's them themselves that consider it unbearable. I'll leave off on one final note, an ethical will. It's an open letter that discusses your values, your favorite memories, words of wisdom, definition of success, or other thoughts to share with loved ones. Oftentimes, when all your money has been spent, 20 years after your death, this is kept in the bedside table of your loved ones, brought out and read once in a while to remind them of you. So, summary, fully rounded estate planning, incapacity planning, and an ethical will is the best way to provide for loved ones in the most cost-effective, quickest, and dispute-free way. I have to say this because I'm a lawyer and I love things like this. This presentation is for informational purposes only. It does not contain legal advice. And on a serious note, everyone's situation is different. So don't rely on this presentation to go out and do your own estate plan, because about 10% of my knowledge was on estate planning was in this presentation. The rest of the 90% could pertain to you, and relying on this presentation to do an estate plan could result in a bad result. So always seek proper legal advice. That's it. That was a whirlwind, but
great.
yeah.
Great. Thank you. Thank you. Thank you, Mike. That was just really well done and succinct and lots of information there. So